Silence no more. Silence no
Well, hello. Welcome to the program. I'm Janet Morena, Executive Director of Priest for Light. And of course, today, look at this. I'm joined by our National Director, Father Frank Pavone. And we're here to announce that this week, my Just Ask Janet show is going to be very special because each and every night this week, Monday through Friday, Father Frank is going to join me and we are going to unpack this Supreme Court decision, the Dobbs decision that overturned Roe v. Wade. So, Father, let's just refresh everyone's memory. I know I was in the studio here on Friday. Father Pavone was at the National Right to Life Convention in Atlanta, Georgia. We were all tuned into the SCOTUS blog.
Because we knew it was going to be a decision day.
We knew it was a decision day.
Yeah, we didn't know which decisions.
If we were going to get Dobbs or not.
Right.
But let's take a look at what happened on Friday.
To go back and rewatch that.
We got it.
Because
We got Dobbs.
No,
We got
no.
Dobbs. We got Dobbs. We got Dobbs.
Are you sure?
We got Dobbs. Yes, right here. Dobbs v. Jackson. We got Dobbs.
Dobbs.
We got Dobbs. It
We
just got handed
have
down.
Dobbs. Oh my goodness. All right.
Okay, let's read.
Held. The Constitution does not confer a right to abortion.
Yes! Oh my gosh!
Roe and Casey are overruled.
Roe is overturned!
The authority to regulate abortion.
Oh my God!
Yes.
Oh, praise you, Jesus!
The authority to regulate abortion is returned to the people.
Oh my God!
The people and their elected representatives.
Thank you,
Roberts concurs in
Yes,
the judgment.
6-3. We won.
Woo!
Praise you.
Oh my
Let's pray.
gosh.
Let's pray right now.
Lord, thank you, because at this moment you have answered the prayers, the sacrifices, the work of pro-life people for 5 decades. Lord God, all their prayers, and so many who have passed on before us, Norma McCorvey and Sandra Cano and Bernard Nathanson and Nellie Gray and Jack Wilkie and so many other people, Mildred Jefferson, and Lord, so many countless people whose names we know, whose names we don't know, who have labored for this day, who have worked for this moment, who have prayed for this outcome, who have dreamt about it, who have wondered, how will this happen? Now, Lord, we see your faithfulness. We see your faithfulness at this moment. We see the answer. And Lord, thank you. We just thank you and we praise you. Janet, what do you think?
Larry.
Oh, I'm like, as they say in Yiddish, verklempt, crying.
Oh my God.
Here. Over 30 years of my life, I've worked for this moment. And I just remember, Father, before Norma passed us on the phone, talking to her and promising her we would work to see this happen. And Norma, we did it. We did it. Everyone did it. The entire pro-life movement did it. Boy, oh boy, Father. So we will always remember June 24th, 2022 at 10:10 a.m. Eastern
Right,
time.
it was the second decision. Yeah.
That was the very moment. And if you notice at first, there was a lot of confusion. We said 6-3. And what really turned out to be, yes, they voted to uphold the Mississippi law.
Yes.
6-3.
Well, that's what it meant. That's what it meant when I said Roberts concurs in the judgment. Here's the decision here. What it meant by the judgment was the judgment to uphold Mississippi's law.
Right.
So that's upheld 6-3.
Right. And then to actually overturn Roe v. Wade and Casey, they mentioned both.
Right.
It was 5-4. Roberts, he was a little chicken. He didn't want to go that far. Well, let's just do Mississippi and leave it at that. But praise God and President Trump, who appointed those 3 other justices. We had then the 5 that we didn't, Roberts, okay, we didn't need you.
We didn't need him. That's right.
Yeah, we didn't need him. They overturned Roe v. Wade and Planned Parenthood versus Casey.
Yes,
so this
they sure did.
And I think, Father, what's happening right now in our country is all the pro-lifers, of course, they're rejoicing, but they're getting bombarded with questions from family, friends, pro-life and pro-choice of both, because everyone is just very confused about what does this mean. And of course, when you turn on the news, you don't get much clarity with the news either, because they're spouting all kinds of rhetoric. They just talk about reproductive health for women, and now they can't get abortions, and that's further from the truth. So, like you just said, we both have a copy, brothers. This is the decision. Look at how many pages. What is this, Father? Over 200 pages.
Yeah.
200 pages. So the first question you can challenge your friends with is when they say, well, I don't understand. Say, well, 200 pages. Has anyone read the decision? That's the first question. Has anyone read it? All these experts, even Nancy Pelosi herself and Biden, have you read the decision? Do you know what it even says?
Yeah.
No. But before we get into decision, I just want to make a very simple point. What the justices did was take abortion out of the judicial branch of government and put it back to the legislative branch where it belongs. So not only does the states regulate, but Congress regulates. So that's where it is right now.
Well, yes, people should use the words that the decision used. It is returned to the people and their elected representatives.
Right.
That's federal and state level.
Federal and state.
So that, in other words, everyone is talking about, oh, it's going back to the states. Well, it's true, back to the states.
But also
the better transition to think about is courts to legislatures.
Right.
Unelected judges
to
elected representatives of the people. Right.
And it's actually, when you say power to the people,
Yeah,
that's
what this is about.
What happened.
Yeah.
Because, before Roe v. Wade, abortion was already legal in numerous states.
Right.
Other states had some restrictions, some had no abortion, because it was at that point the power with the people. The problem was Dr. Bernard Nathanson, Larry Lader, and the National Organization for Women, they weren't satisfied waiting for state by state to begin to regulate abortion.
Well, there had already begun to be some change, like you said, and the decision points out that at the time of Roe, 30 out of the 50 states, 3/5 of the states, prohibited abortion throughout pregnancy.
Right.
So it was a pro-life nation. There was no question.
And they weren't satisfied with that.
Yeah.
So they came up with the scheme to kind of like, this is moving way too slow for us. We want abortion in all 50 states. So we just got to create and fabricate a way to get there.
Mm-hmm.
And we all know that Roe v. Wade and Doe v. Bolton were built on lies, which we can get into at another time. But looking at the decision, Father, first of all, Alito's document leaked over a month ago was only, by the time it leaked, 90 some odd pages. This is well more than double.
Well, yes, but this includes all the concurring opinions and the dissents.
Oh, okay.
So that's why it ends up being 213 pages. In fact, why don't I show on the board how this breaks down?
Yeah.
What's in all these 213 pages?
Yeah, it's a lot, brothers. Look at this thing.
So let's go to the board.
All right, let's go to the board.
All right, so you've got the Dobbs case. Dobbs, by the way, is the state health official in Mississippi.
Right.
People are wondering
who's
that?
And it was versus Jackson Medical.
Yes,
Right.
and they're abortionists.
And they're abortionists. Right.
So, but the opinion consists of what's called the opinion. Okay. So the opinion of the court, the majority opinion, authored, like you say, by Alito and joined in by Kavanaugh, Barrett, Neil Gorsuch, and of course, Thomas. So there's the five. There's the five altogether to reverse Roe. And Chief Justice Roberts for upholding the Mississippi law, but not for reversing Roe. So that's where you get the 6 to uphold Mississippi. In this 213 pages, then, you have a number of other documents. After the opinion of the court, You have Justice Thomas issuing a
concurrence.
concurrence.
Right.
You have Justice Kavanaugh,
Also,
who
concurrence.
issued his own concurring opinion.
Right.
Okay. Kavanaugh, concurring opinion. Then you have another document by the Chief Justice, again, upholding Mississippi, but not reversing Roe. And then you have, of course, the dissenters.
Oh, finally, you got to change the marker.
Yeah, you
Red.
got to change it into red.
Blood. They
Yeah.
have blood on their hands.
Well, they're terrible.
Yeah, so
The dissenting opinion,
blood on their hands.
of course, is Breyer. He leaves the court now, by the way, as this
Right.
term ends, right,
Right.
this week. He leaves the court
He exits.
with a terrible record on abortion. He even upheld partial birth abortion. And then you
Kagan.
have the two ladies, yes, Kagan
And of course,
and Sotomayor.
Sotomayor, the most radical of the three.
Okay, so that's what that's what, and in at the end of the opinion of the court, by the way, you have a very interesting appendix. All right, we saw this in the leaked draft. In the appendix of the opinion, you have the state laws, and we'll talk about the significance of this, which were in place when the 14th Amendment was ratified, and shortly thereafter in the mid to late 1800s, because the other side, the dissenters, et cetera, and the other supporters of Roe and Casey, claim that it's in the 14th Amendment liberty clause that they find the right to abortion. But
The word abortion is not even in the Constitution.
no, nowhere near it.
Nowhere near it. So, I mean, that's a little crazy. But I'm just curious here about Roberts, all right, with Mississippi, and that he didn't want to overturn Roe. So in his papers there, his is still called the concurrent?
Yeah,
Okay.
yeah.
So what does he actually say? Because I know you've read, I haven't read the whole thing, but you have.
Yeah.
What's Roberts basically saying?
Well, he's saying, first of all, that what Mississippi originally asked us to do was simply to uphold their law. And they said, oh, by the way, we think you should reverse Roe and Casey, but at the very least, Mississippi said, at the very least, just uphold our law.
I
Okay,
see.
now their law prohibits abortion prior to viability.
Right.
And that was the nub of the matter, because Roe and Casey said at the center of what they were saying was that prior to viability, the state could not prohibit abortion.
Right.
So you have a clear conflict here with Roe and Casey. So what Roberts was saying was, look, the court shouldn't go further than it has to go to resolve the dispute that has been brought before it. And his argument, and you can hear him saying this when you listen to the oral arguments from December 1st, which, by the way, people can go back and listen to.
Right.
The recording is there. We've got it linked from our SupremeCourtVictory.com. You hear him making this argument. He says, oh, look, 15 weeks, that seems like a lot of time. And that is more time, in fact, than most of the nations in the world give the women of their country to make the decision for abortion.
Oh,
He
Father,
said
all
so.
of Europe is only 12
Yeah,
weeks.
12 weeks.
12 weeks.
So he was saying, look, he said, shouldn't the legality of abortion mean, and this is what he's saying, like you say, in his concurrence, shouldn't it mean that the woman has a reasonable opportunity to have an abortion? You know, now, if he had, and he didn't come anywhere near this because he was the only one of the 9 justices saying this, and neither of the parties in dispute, i.e. the state of Mississippi or the Jackson Women's Health Organization and their abortionists, or, by the way, there was a third party involved, the Biden administration. They argued in this. We should put that up on the board in just a minute. We'll explain that.
Oh,
But
they
what
had
I'm-
to throw their 2 cents.
they had to
in.
throw their 2 cents. But the point I'm making is nobody among all these people was advocating for what Roberts said, that let's find some middle of the road position. What they were saying, and the other side said, hey, listen, you have a choice here. Either strike down the Mississippi law, otherwise you're completely striking down Roe and Casey. They
Oh,
said
really?
they said there's no middle ground.
Huh.
Yeah.
So Roberts wanted the middle ground, and the pro aborts didn't want the middle ground.
That's right. If he had somehow gotten 4 others to agree with him,
Right.
we would have had a new standard, apparently, where Casey had the undue burden standard, okay,
Right.
but they still held to the viability line. Roberts would have introduced apparently what would have been a reasonable opportunity standard. If the woman has a reasonable opportunity to get an abortion, that's enough. Now, here's one of the problems with this. He said, let's leave till another day the question of actually reversing Roe and Casey. But what the majority pointed out was, hey, that other day
Is here.
would be coming pretty quickly after this because, okay, you uphold a 15-week limit. Well, what about the states that have passed the 12-week limit?
And what about the heartbeat?
And the heartbeat is 6 weeks.
Yeah.
So that's going to what they're saying is that's going to quickly reach our desk after this.
Because, Father, what people have to realize, when the Supreme Court accepted Dobbs, it put a freeze on all these other cases, didn't it? At the federal level, that was still percolating.
In regard to abortion, the
Yes.
judges
judges
were
all
saying,
said,
well, hold on.
Hold on.
Yeah.
We're going to wait for Dobbs
Sure.
before we decide this case.
Sure, because they know that they're responsible for applying
they say.
vertical precedent, as it's called. Yeah.
So, that's why this case was so important. And that's why, the point you just made, the justices was saying, no, we can't wait, because if we somehow do what Roberts wanted, but the next court will have the heartbeat
the 12-week
challenge and this challenge and this challenge.
Of course, it's never ending.
First of all, they're very aware of all these other cases on abortion that are percolating throughout the other federal courts.
Of course,
They know.
Yeah.
So looking at that landscape, they were saying, well, we have to bite the bullet and deal with this now.
That's exactly right. Yes.
And that was the attitude. They were strong enough to say, it's time to bite the bullet. And Roberts was like, no, please, no, not yet.
Yeah.
Whenever we did it or they did it, you were going to have the conflict we have right now.
Yeah.
Because people don't even understand Roe v. Wade. Very, very few. Come on, Father, you and I, with all the talks we give all over the country and all the programs we do, don't we still, when you say abortion is legal through all 9 months of pregnancy, according to Roe v. Wade, most people go, huh? Really?
Yeah.
Yes.
Yeah.
And the viability standard is another shaking ground, because
very.
when Roe was decided, viability back then was all the way at 28 weeks.
Yeah.
Now it's down about 22, 23.
Yeah.
So, and that will continue to change. So that's not steady ground either. Right?
No, it's not steady ground, and it doesn't have any constitutional basis. And it's furthermore, it was brought in at the last minute in the Roe v. Wade decision.
Right.
And you know what? Ultimately, when I say the last minute, I mean really, literally, just about the last minute.
Well, the whole decision was written.
The decision was written. They were tending towards drawing the line after the first trimester. That's where they were going. And then there was a memo circulated among the justices in December of 72. That's 1 month before the decision was issued.
Right.
1 month before the decision was issued in Roe, they started, talking about circulating this memo about, well, maybe we should move the decisive line to viability. And you know what the reason ultimately was? You can see it in these memos. Well, some women are going to be ambivalent, and they're going to be uncertain, and we ought to give them more time to get an abortion. Now, what does that have to do with the Constitution? The viability rule, it's amazing, because the other side argues, it's a principled rule. And you ask them, well, why is viability the point where only then does the state have a compelling interest to protect the baby? Oh, well, because that's the point at which the baby has a reasonable chance of surviving outside the womb. And constitutional commentators have said that mistakes a definition for a syllogism. In other words, if you say the reason why I'm drawing the line at viability is because that's when the child can survive outside the womb, you didn't give a reason. All you did was give a definition of what viability is. But what we want to know is, why is that the point, and only that the constitutional right of the state to ban abortion comes into play?
Right.
There's no reason. Then,
Yeah.
and see, this is one of the big weaknesses of Roe. As we go through this opinion, we're going to see how they argue. One of the key arguments is Roe was very weak in its reasoning. And this is one of the examples of that weakness. And Casey was similarly weak. See, Casey reaffirmed Roe, but it didn't bolster its reasoning. In fact, it shied away from its reasoning
Right.
because they realized this is
And,
garbage.
you know,
And-
Father, Ruth Bader Ginsburg herself,
Yes,
even though she was pro-abortion justice, she thought Roe was badly
Yes,
written and
exactly.
it wasn't good law.
because it wasn't.
She herself said, you know, and that's why these groups, these radical groups that are picketing, saying Ruth sent us. The last thing Ruth Bader Ginsburg would be sending you to the justice's
Yeah.
homes to protest.
She was one of many people who agreed with the conclusion. In other words, the abortion should be legal, but wasn't too happy about the reasoning.
Well, no, I think she saw all the weakness of it, and that's what she saw one day. It could fall because of the weaknesses, I think.
Because of the weaknesses of the reasoning. Yeah.
That's right.
There was no principle. The other side, it's a principled line to draw as viability. Based on what principle,
Right.
and that's what the justices were getting at.
Well, and then, right now, Father, in the news, the other big thing is we have Susan Collins and one or two others who are saying that Kavanaugh and Barrett lied to them, during the hearings when they said they were asked, does precedent matter and would you uphold things and all that?
Well, let's look at that. I mean, should I go to the board here and
Sure.
then maybe just put a thing? Yeah, because I saw that too. And of course, we were listening very carefully when we were going through those confirmation hearings for
Right.
Kavanaugh, for
Right.
for Gorsuch and for Barrett. We were listening very carefully about what they were going to say.
Oh, and the
about
ridiculous
Roe.
Father on the left, some of the extremists they're saying we should impeach them for lying. That's the
Well,
new
this
mantra
is,
going out there.
this goes to the track that these people are on goes to show, brothers and sisters, that they've got no basis
Right.
for this. They've got no basis at all for what their position is. So the justices are asked, what about Roe? Now, judicial ethics demands, and Jan, you mentioned Ruth Bader Ginsburg, she
Right.
made this clear. Ketanji Brown Jackson, the newest one that was confirmed.
Well, she couldn't even
she
tell
made
what a
this
woman
clear.
Was, remember?
Yeah, but the point is that the judicial ethics says you can't comment on how you might judge
A particular case, right?
of a particular case. Why not?
Because
on
you're
a
trying to,
case.
because you're trying to predict the future, Father. You're
Yes,
trying to
not only
say,
that.
whatever thing came before me, no matter what this said, I would do this. That it's trying to, right?
Yeah, and if you were to say that,
Right.
you're being unfair to the parties who might come before the court with a dispute.
Right.
Because you're tipping your hat ahead of time. You're saying how you might judge. First of all, you don't know the facts. Cases that come before a court are based on the specific facts of the case. So you have to wait till you have the facts of that case.
Right.
And it's only in fairness to the parties involved. You can't say in advance. So if anyone expected them to say, I will uphold Roe or I will oppose Roe,
Right.
they're asking them to cross a line, an ethical line. So they did not cross that ethical line. What they said was what we could have all said, which is that it's undeniable that Roe, is precedent. All that means is that the court decided in a particular way on abortion, and various other cases after that reaffirmed the precedent. Now, Roe is precedent.
Right.
Is that the same thing as saying I oppose it, or I would judge against it, or I uphold it, or I would judge for it? That is not to say that, because we all know that precedent can be reversed.
Right.
And
Well, Brown versus Board of Education is the big one there.
yes, and every justice has voted at one time or another in one case or another. Every justice has voted to overturn precedent. Every one of them. So this nonsense that, they lied, is nothing but nonsense. It's
not knowing what the whole thing is about to begin with,
Yeah.
and just bantering around a bunch of dialogue, right?
yeah. Yeah.
Unbelievable.
No, these people are unbelievable. They have no basis for upholding Roe, Casey, or abortion.
Yeah. Well, I think we've set a good groundwork here as a beginning. There's so much to talk about. With
Yeah, we're going to go through section by
we're
section
gonna
this
do, brothers and
week.
sisters, this whole week. You are going to get Supreme Court education like 101 here. And Father Frank, I have to tell you, he's even better than me. I mean, he's read all the decision already. But he read all the briefs, everything. So he's like the expert. But you know what the most important thing, I think, Father, I want to remind everyone is you better be taking out your notepad and taking notes during these sessions, because you need the talk. And then Father is also going to write little fact sheets for you. Okay, we're going to get those up online once we do the classes. So you're going to be empowered with being able to have those discussions. Because some people I know, they're telling me, oh, I'm snoozing a few people on Facebook because I just can't take all this like bantering, because some of them don't even know what's going on. They don't want the truth about the whole thing.
Yeah.
But I just want to remind Father, everyone, before we go, if you do want to read something that's going to help you with the dialogue, when you agree, Father, my new book, Everything You Need to Know About Abortion for Teens. I wrote it for teens, but guess what? The adults need it now with all this talk going on. And in the middle, Father, of course, as you know, we have pictures of the unborn baby starting at 7 weeks. It's like the little baby album. So this is a great tool for you to use, brothers and sisters. Right now, we're all just everyone's finally talking about abortion. So if you go to abortionandteens.com, I will personally autograph and personalize a book for you. Abortionandteens.com. Well, Father, I think they'll join us again tomorrow night, where we are brothers and sisters. Father is going to take a deep dive starting tomorrow night. And we're going to even take questions from you, our audience. So store up all your questions. And every night from now, Monday through Friday this week, we are diving into the Dobbs decision for you. So, Father, closing remark before we go?
Roe has been overturned. And no longer is the court putting an obstacle, brothers and sisters, in the way of you and me working with our legislators to protect the babies in the womb. No longer. And what we're going to see, Janet, in the coming days, we already see it, the trigger laws are taking effect.
That's right.
And the injunctions are going to be lifted on those laws that have been tied up in court over this recent year, at least, while Dobbs was being decided. So the protection of the unborn is advancing fast and furious during these very days.
Well, until we talk to you again tomorrow night, this is Janet Miranda, Executive Director, Father Frank Pavone, National Director. God bless. Have a good evening.
I will be sad.